If you are thinking about doing businesses in Colombia, there are 5 key aspects you need to know to properly structure your company and comply with local regulations. It is not just about understanding the market and the economy. It is also about knowing the legal framework and choosing the best corporate structure. If a foreign investor wants to operate permanently in Colombia, they must establish a legal entity. This can be done either through a branch or a subsidiary. But what exactly qualifies as a permanent business? Colombian law does not provide a precise definition, but several factors help to determine it. The nature and scope of the activities, the infrastructure and its operations in the country, the regularity of commercial activities, hiring employees in Colombia, and if your business meets these criteria, you must likely need to establish a legal entity in Colombia. A branch is not an independent entity. The foreign company remains fully responsible for the obligations of the branch. On the other side, a subsidiary is a separate company with its own legal identity, meaning it assumes its own rights and liabilities. Which option should you choose? It depends on several factors such as the level of operational flexibility you require, whether the parent company is willing to assume its obligations in Colombia, and the level of risk the parent company is prepared to take in the country. In Colombia, the simplified stock company is the most widely used business structure because of its many advantages. It can be formed with just one shareholder. A board of directors is not required. It can be created quickly through a private document, avoiding complex processes. It does not require a specific business purpose or a fixed duration term. These features make the SAS one of the most flexible and convenient options for investors seeking to operate in Colombia with minimal complexity. Another key aspect of Colombia's commercial regulations is limited liability. What does this mean? If you create a SAS or a subsidiary, investors are only liable up to the amount of capital they contributed in the company. This provides security, protecting the personal assets of its shareholders. However, in cases of fraud or abuse that harm third parties, shareholders may be held liable beyond their contributed capital. This legal framework gives foreign investors confidence and security when operating in Colombia. One important fact is that Colombia does not require a local partner to operate. You can be the sole owner of your company without any restrictions. Additionally, SAS investors enjoy flexibility regarding capital contributions. There is no requirement to pay capital immediately. Shareholders can define the timeline for capital payment. The law allows you up to 2 years to pay the subscribed capital. With a modern and flexible legal framework, Colombia is an attractive destination for foreign investment.